এই মুহূৰ্তত লৈ আহিছো ৰাজ্যবাসীৰ বাবে এটা গুৰুত্বপূৰ্ণ খবৰ কিয়নো উচ্চতম ন্যায়ালয়ে আজি এক ঐতিহাসিক ৰায় প্ৰদান কৰিছে কিয়নো নাগৰিকত্বৰ বৃত্তি বৰ্ষক লৈ এইবাৰ উচ্চতম ন্যায়ালয়ে এক গুৰুত্বপূৰ্ণ সিদ্ধান্ত গ্ৰহণ কৰিছে জনাইছো এই গুৰুত্বপূৰ্ণ খবৰটো 1971 চন হ'ব নাগৰিকত্বৰ বৃত্তি বৰ্ষ আৰু অসমত নাগৰিকত্বৰ বৃত্তি বৰ্ষক লৈ চলি থকা বিতৰ্কৰ অন্ত পৰিছে উচ্চতম ন্যায়ালয়ে আজি এক গুৰুত্বপূৰ্ণ ৰায়দান প্ৰদান কৰিছে 4-1 6 পক্ষত ৰায় দিলে উচ্চতম ন্যায়ালয়ে মুখ্য ন্যায়াধীশৰ নেতৃত্বত বহা আদালতে প্ৰদান কৰিছে এই ৰায় 1971 চনৰ 25 মাৰ্চেই হ'ব অসমত নাগৰিকত্বৰ বৃত্তি বৰ্ষ আৰু পুনৰ জনাইছো অসমত নাগৰিকত্বৰ বৃত্তি বৰ্ষ 1971 চন 1971 চনৰ 25 মাৰ্চেই হ'ব অসমত নাগৰিকত্বৰ বৃত্তি বৰ্ষৰ তাৰিখ নাগৰিকত্বৰ বৃত্তি বৰ্ষক লৈ পুৱা 10:30 বজাত গুৰুত্বপূৰ্ণ ৰায়দান উচ্চতম ন্যায়ালয়ৰ 1971 চনৰ 25 মাৰ্চেই হ'ব বিদেশী চিনাক্তকৰণৰ বৃত্তি বৰ্ষ নাগৰিকত্ব আইনৰ 6 ক দফা বাহাল ৰাখাৰ সিদ্ধান্ত গ্ৰহণ কৰে সৰ্বোচ্চ ন্যায়ালয়ে এই চূড়ান্ত ৰায় প্ৰদান কৰে 5জনীয়া বিচাৰপীঠে 4-1 ৰায়দানৰ মাধ্যমেৰে 1971 চনক বৃত্তি বৰ্ষৰ সিদ্ধান্ত গ্ৰহণ কৰিছে উচ্চতম ন্যায়ালয়ে দেশৰ মুখ্য ন্যায়াধীশ DY চন্দ্ৰচূড় ন্যায়াধীশ সূৰ্যকান্ত MM সুদ্ৰেশ JB পাটিৱালা আৰু মনোজ মিশ্ৰৰ দ্বাৰা গঠিত বিচাৰপীঠে এই ঐতিহাসিক ৰায় প্ৰদান কৰিছে উল্লেখ্য যে নাগৰিকত্ব আইন 1955 6A ধাৰাক প্ৰত্যাহ্বান জনোৱা আবেদনক লৈ এই ৰায় দিয়া হয় সন্মিলিত মহাসংঘৰ মতিউৰ ৰহমানে বৃত্তিবৰ্ষ সন্দৰ্ভত গোচৰ দিছিল ন্যায়ালয়ত 6 ক ধাৰাক প্ৰত্যাহ্বান জনাই অসম সন্মিলিত মহাসংঘই তৰিছিল গোচৰ 2023 চনৰ 12 ডিচেম্বৰত 5জনীয়া বিচাৰপীঠে সংৰক্ষিত কৰি ৰাখিছিল ৰায়দান উল্লেখ্য যে অসম চুক্তি অনুসৰি বিদেশী চিনাক্তকৰণ আৰু বহিষ্কৰণৰ ভাৱে নিৰ্ধাৰিত 1971 চনৰ 24 মাৰ্চ তাৰিখৰ ভিত্তিবৰ্ষক প্ৰত্যাহ্বান জনাই দাখিল কৰা হৈছিল এই গোচৰ আৰু অৱশেষত 1971 চনৰ 25 মাৰ্চেই হ'ব নাগৰিকত্বৰ বৃত্তিবৰ্ষ
The migration from East Pakistan to Assam was in great numbers after the partition of undivided India. And since the migration from East Pakistan after Operation Searchlight would increase, the yardstick has nexus with the object of A, reducing migration, and B, conferring citizenship to migrants of Indian origin. Section 6A will be under-inclusive only when all those who are similarly situated with respect to the object and on the application of the rational yardstick are not included. Similarly, the provision would be over-inclusive only when those who are not similarly situated with respect to these two parameters are included. That not being the case, Section 6A is neither under-inclusive nor over-inclusive. Article 355 casts a duty on the Union of India to A, protect every state against external aggression, B, protect every state against internal disturbance, and C, ensure that the government of every state is carried out in accordance with the provisions of the Constitution. All these three phrases feature in Part 18 of the Constitution, which deals with emergency powers. If the duty of the Union to safeguard states against external aggression is justiciable in view of Article 355, then petitions could be filed claiming that the Union has not appropriately dealt with any of the situations referred to in Article 355. It could also be contended that emergency powers ought to have been invoked by the Union to deal with the situations appropriately. Reading the duty in Article 355 into a right would effectively place the emergency powers with citizens and courts. Such a consequence would be catastrophic for the federal structure of the Indian Constitution and would subjugate the constitutional status of states. Article 355 cannot be elevated as an independent ground of judicial review in view of the purpose of the provision as a justification clause and the impact of such a reading on the federal framework of the Constitution. As a matter of constitutional principle, the mere presence of different ethnic groups in a state is not sufficient to infringe the right guaranteed by Article 29(1). Article 29(1) confers the right to conserve, which means the right to take positive steps to protect culture and language. The petitioners ought to prove that the necessary effect of the law that promotes the presence of various ethnic groups in a state is that another ethnic group is unable to take steps to protect their culture or language. The petitioner also ought to prove that the inability to take steps to conserve culture or language is attributable to the mere presence of different groups. The detection of the foreigner is an elaborate process that required the state to build manpower and infrastructure for its implementation. The legislature conferred the state with the duty to implement the provision after it had built sufficient infrastructure for the same. The purpose of Section 6A3 was to provide a long-term solution to the issue of the large influx of migrants from Bangladesh to Assam. It is true that one of the causes of concern which led to the Assam students' movement and culminated with the Assam Accord was a dilution of the electoral right of those native to Assam because of the inflow of migrants. However, the purpose of Section 6A3 cannot be limited to it. The objective behind the enactment of the Citizenship Amendment Act 1985 was to deal with the larger problem of whether Bangladesh migrants of Indian origin could secure citizenship in India. The objective of the provision must be understood in the backdrop of the Indian policy on post-partition migration and the Assam movement. The principle of temporal unreasonableness cannot be applied to a situation where the classification is still relevant to the objective of the provision. The process of detection and conferring citizenship in Assam is a long drawn-out process spanning many decades. To strike it down due to lapse of time would be to ignore the context and object of the provision. Registration is not the de facto model of securing citizenship in India. The use of the deeming fiction in Section 6A2 obviates the need for registration. The provision does not contemplate a registration regime for persons who fall under this category, similar to Sections 3 and 4 of the Citizenship Act. Section 6A2 cannot be held unconstitutional for the only reason that it does not prescribe a process of registration. So I've also come to the conclusion that the provision is constitutional.
Speaking on behalf of myself and my brother Justices M.M. Sundresh and Justice Manoj Mishra, we have also upheld the constitutionality of Section 6A. We have, based upon the arguments, divided the issues which came for our consideration in two parts: prefatory issues and then the challenges regarding constitutionality. On prefatory issues, there were two objections raised on behalf of the respondents with regard to the maintainability of the very challenge. One was that the power of judicial review, whether it will extend to analyzing the constitutionality of Section 6A. And the second was that the writ petitions were barred by delay and laches. So far as these two plain objections are concerned, we didn't find any merit. Both we have turned down. Then on merits with regard to the constitutionality, we have formulated certain questions like: does Section 6A offend preambular values like fraternity? Is Section 6A ultra vires part 2 of the Constitution? Does Section 6A create an unreasonable classification which violates Article 14? Does Section 6A suffer from manifest arbitrariness? Does Section 6A violate the rights provided to indigenous communities under Article 29? Is Section 6A ultra vires Article 21 of the Constitution? Does Section 6A violates the political rights of the Indian citizens in Assam under Article 326? Does the operation of Section 6A causes external aggression and internal disturbance culminating in the invocation of Article 355? Does the Citizenship Act conflict with the provisions of the Immigration Expulsion from Assam Act 1950? And if so, how can the two legislations be harmoniously interpreted? And lastly, whether Section 6A violate international laws. While examining all these issues, as I said, the preliminary objections on judicial review and delay and laches we have turned down. On the question of fraternity, our conclusion is that in many ways the petitioners want fraternity to be interpreted in a highly restrictive manner, which allows them to choose their neighbors. Since this approach runs contrary to the very idea and ethos of the fraternity that was envisaged by the Constituent Assembly and as subsequently interpreted by this court, it cannot be accepted. Our reading of the Constitution and precedents is that fraternity requires people of different backgrounds and social circumstances to live and let live. The nomenclature of fraternity itself is self-explanatory to the extent that it exhibits the notion of inclusiveness and togetherness, as opposed to restricted applicability. Thus, it becomes imperative to refrain from employing this concept in a negative manner that selectively applies it to a particular segment while labeling another faction as illegal immigrants solely based on the alleged unconstitutionality of Section 6A. The other contention was that 6A violates Articles 6 and 7 of the Constitution of Part 2, that we have turned down, saying the petition's contention that 6A is unconstitutional as it prescribes different dates in comparison to Articles 6 and 7 cannot be accepted, because Article 6 does not prohibit the granting of citizenship after the cut-off date of 19 July 1948. It only specifies the fulfillment of certain conditions, which, as mentioned above, are also present in Section 6A, subclause 3. While Section 6A, clause 2 grants deemed citizenship without these conditions, the competence of Parliament to prescribe different conditions, which will be analyzed in detail in the later part, is well embedded in Article 11. Similarly, while Article 7 prohibits citizenship to people who re-migrated to India, this is only a subclass of people who have been granted citizenship by Section 6A. Since Section 6A grants citizenship even to people who migrated for the first time, the class of re-migrants is severable from this provision. As will be discussed in the following paragraphs, the Parliament was competent to specify different conditions for this subclass also. On the question whether the Parliament had the competence to specify different conditions under Article 11, we have upheld that power, that Parliament possessed the legislative power to lay down and specify different conditions, and such power is not controlled and regulated by Part 2 of the Constitution. The other contention raised was based upon the dual citizenship. That also has not found favor with us, and we have held. Therefore, based on the aforementioned reasons, we are of the considered opinion that the framework outlined by Section 6A is that an individual falling under Section 6A2 and 6A3 can only assert Indian citizenship. Such individuals are presumed to have relinquished their previous citizenship. If authorities have reasons to believe that the previous citizenship is still being exercised, they are empowered under Section 9 of the Citizenship Act and associated rules to take steps to revoke the Indian citizenship of the delinquent individuals. Consequently, it can be deduced that the Section 6A does not contradict Section 9 of the Citizenship Act, and we declare so. On the question of violation of oath of allegiance, again it did not find favor with us. We have said, moreover, the absence of such an oath does not absolve the immigrants from their obligation